Hello and thank you for listening to this information session for continuing care operators on the application for licensing process. Today we will go over what licenses there are under the Continuing Care Act. In addition, we will discuss what operators can expect in terms of licensing and what steps are needed from operators. We will introduce the changes to the application form and review an example application form together. The intent is to clarify for operators what to expect when filling out the application form and what is required. We will also review which supporting documentation is required to supplement the application form, and we will also touch down on transitional licensing. Ending our session, we will go over terms and conditions of licenses, posting requirements, reporting requirements, and the right to appeal a licensing decision. Purpose of today's session. For current and new operators, the information session will provide a clear understanding of what is required to obtain and maintain a license, as well as what to do to prepare for the effective date of April 1st. Questions we'll answer today: how do I obtain a license? Why do I need a license? What documents are required? What is the licensing process? Who do I contact if I have questions? The Government of Alberta has passed a new Continuing Care Act, which came into effect April 1, 2024. The new Act will provide consistency across continuing care and ensure Albertans will receive high-quality care and services. Intent of the new Act is aimed at maintaining successful elements of current legislation, seeks to apply consistent standards across the continuing care system, introduces new provisions to fill gaps and address challenges in the existing system, focuses on enhancing the overall effectiveness of continuing care services. As part of this new legislative framework, important changes are being made to how and when supportive living accommodation and continuing care home, including hospice, operators need to obtain a license from Alberta Health. A significant reason for the new continuing care legislation is to address gaps with the previous legislation. The previous legislation was complex, fragmented, and in many instances outdated. This may create barriers to implement shifts to transform the continuing care system to support Alberta's aging population. It was unclear what services were available in different settings and programs and who was responsible for the costs. Some settings were not reflected throughout the past legislation. For example, palliative and end-of-life care, designated supportive living. Palliative end-of-life care is referred to in the Home Care Regulation, Continuing Care Health Service Standards, and Nursing Home Operations Regulation, but legislation did not accurately reflect the structure and delivery of palliative end-of-life care and quality oversight of palliative end-of-life care. It did not reflect the importance of resident and client quality of life. There were inconsistencies and gaps for compliance and monitoring around licensing, authority to inspect, complaints, incident reporting, ability to exempt operators from specific licensing requirements, etc. Furthermore, the COVID-19 pandemic has revealed and exacerbated system-level issues across the continuing care sector. The gaps that previously existed became more apparent and concerning over the course of the pandemic. The legislation begins with a preamble, which highlights core principles that are important to the continuing care system. This is not an enforceable part of the Act, but these concepts will be reflected throughout the new legislative framework and are foundational to other transformative initiatives underway in continuing care. This also aligns with key principles that emerged through the Facility-Based Continuing Care Review. The final report for the Facility-Based Continuing Care Review outlined 43 recommendations that would transform and modernize Alberta's facility-based continuing care system. The key principles identified in the preamble include: the continuing care system is guided by and provides continuing care in accordance with the principles in the Alberta Health Act. Respect for the diversity of Albertans who access continuing care. The government is committed to ensuring that the delivery of continuing care is based on a person-centered approach. Quality of life of continuing care residents and clients is the highest priority for the Government of Alberta with respect to delivery of continuing care services. Family and friends who act as caregivers play a significant role in the lives of continuing care residents and clients in helping to determine how to best meet their needs. Continuing care staff are well trained and supported to enhance the quality of life of residents and clients. Continuing care residents and clients deserve to be treated with dignity and respect, taking into account their physical, mental, social, spiritual, and cultural needs. Government of Alberta supports the wishes of continuing care residents and clients to age in place or in community and to remain living as a couple or with a companion. The previous legislative framework for the continuing care sector was complex and comprises content from 6 acts, 6 regulations, and 3 sets of standards. In addition, some of the legislation dates back to 1985 and doesn't accurately reflect the continuing care system in practice, and in some cases may act as a barrier to flexibility and person-centered care. Given the challenges with the previous legislation, one new overarching legislative framework is being introduced to regulate the full spectrum of continuing care settings. The Act, which was introduced in the Legislative Assembly as Bill 11 and received royal assent in spring of 2022. The Act is intended to be framework legislation with authority and oversight for future regulations, standards, and other supporting policy tools. The Act is just the first step in the new legislative suite of tools. Additional requirements are being enabled through regulations, standards, and policies. Some changes to licensing include continuing care home license and types, long-term care and hospice, now to be licensed, issuing of transitional licenses for certified and licensed facilities to transition into the new Act, an enhanced licensing process, and longer license duration. Topic 1. License requirement. Those with licenses prior to April 1, 2024 were licensed under the Supportive Living Accommodations Licensing Act. This includes the supportive living accommodation, non-funded, and designated supportive living, health-funded settings. Nursing homes and auxiliary hospitals were certified instead of licensed. As of April 1, 2024, those that were issued a Supportive Living Accommodations Licensing Act issued license and those with a valid certification need to have a license under the Continuing Care Act. Licensing is also new for hospices under the Act, Continuing Care Home Type C. Commonly known terms for continuing care home types are included in the slide: long-term care, designated supportive living, hospice. Commonly known supportive living settings may include group homes, lodges, supportive living, non-health funded, non-facility-based care. There are 2 categories of licenses that can be issued under the Continuing Care Act. These are the Continuing Care Home License and the Supportive Living Accommodation License. The license needed is determined by the level of support, accommodation, and health services provided to the residents, known as the basket of services. A continuing care home license includes types categorized as A, B, and C. These include what was formerly known as long-term care, designated supportive living, health-funded, and hospice. A supportive living accommodation license does not have types, and this would be settings formerly known as supportive living, non-health funded. Supportive living accommodation licenses are defined by determination criteria, and facility-based care is not provided under this license. Supportive living accommodation settings and continuing care home Type B settings are familiar with the licensing process, as under the Supportive Living Accommodations Licensing Act, they were required to be licensed. For continuing care home Type A and C operators, this is a new process under the Continuing Care Act. In an upcoming slide, eligibility criteria will be discussed for continuing care home and supportive living accommodations. Alberta Health will determine the type of continuing care license to issue based on the facility-based care that is provided at the site. The Regional Health Authority designates the type of facility-based care that is to be provided under each license type, such as Type A, commonly known as long-term care, Type B, designated supportive living, publicly funded, Type C, hospice, for operators that enter into agreements with the Regional Health Authority. Based on this, Alberta Health can determine which continuing care home license to issue. Further along, we will describe the basket of services for facility-based care and what those are. Settings currently known as supportive living include lodges, group homes, supportive living, not designated supportive living, etc., where there is no facility-based care provided and health funding not provided. The Supportive Living Accommodation License authorizes the licensee to operate a supportive living accommodation and provide supportive living services to the residents of the accommodation. The slide describes the determination criteria on what would qualify a site as needing a supportive living accommodation license. There may be instances where a site was not previously eligible for licensing, and now as part of this determination will become a supportive living accommodation and require a license. Who does not require a license? Home and community care providers, accommodations with less than 4 residents. So if residents are receiving supportive living services, but not meeting threshold of 4 persons. To note, if a supportive living accommodation threshold temporarily falls below 4 residents, the Act will still apply as it is temporary. Shelters, hostels, referring to housing to support persons who have experienced homelessness, in which they are provided on-site services and housing. Independent living could refer to life leases where a person buys an accommodation, but if they pass away or need a different level of care, the accommodation is bought back by the facility. The person can purchase services as needed with the site or arrange with home care independently. An overall expectation for both categories of license is that services are provided in a manner that ensures the health, well-being, and safety of residents and clients. What are the baskets of services? In the next slides, we will look at some examples of what these are. The basket of services for continuing care homes is described in this slide. Under Health, Case Management, Professional Health Services, Physician Services, Palliative Care, End-of-Life Care, Life Enrichment Services, Therapeutic and Special Diets. Under Other, Medication, Supplemental Nutritional Products, Personal Care Services, Medical Surgical Supplies, Assistive Equipment, Pharmacist and Pharmacy Technician Services. Under Accommodation, Food Services, Housekeeping Services, Laundry Services, General Administration and Business Support Services, Facility Maintenance, Operation, and Utilities. The basket of supportive living accommodation services is shown in this slide. Under Safety, Security, or Personal Welfare, Systems and Processes to confirm physical presence and welfare of residents, Tracking of absences of residents. Under Meals or Accommodation, Meals and Nourishment Services, Bedding, Towel, or other linens, Housekeeping Services, Laundry Services, Access to Personal Choice Services, Social or Leisure Activities, Holding money on behalf of residents, Holding residents' property for safeguarding, Assisting, reminding residents to take prescribed medications. Please note that long-term care settings will now be licensed rather than certified. Long-term care operators will now be expected to submit regular license renewal applications and required documentation. This change will also be reflected in the accommodation standards, as the corporate status standard and certificate posted standard will be removed, as they will no longer be needed. Corporate status will be asked for in the application, and instead of the certificate to be posted, it will be the license to be posted. Hospice operators have never been licensed before and will be expected to submit an initial application and subsequent renewal applications prior to the expiry of their license. Supportive living accommodations and Type B continuing care homes, formerly designated supportive living, publicly funded, are familiar with the licensing process as they have been doing so under the Supportive Living Accommodations Licensing Act. There have been changes in the Act to licensing requirements, but the overall process is similar. Those who had licenses prior to April 1st, 2024 Continuing Care Act implementation were licensed under the Supportive Living Accommodations Licensing Act. This would be the supportive living accommodation, non-health funded, and designated supportive living health funded settings. Nursing homes and auxiliary hospitals had certification instead of licensing. As of April 1st, 2024, those with a Supportive Living Accommodations Licensing Act license and those with a valid certification would need to have a license under the Continuing Care Act. Licensing is also new for hospices under the Act. Topic 2. Transitional licenses. Transitional licenses will be issued to sites with valid certificates and licenses. The transitional license allows for operators to transition into the new Act. An operator must apply under the Continuing Care Act prior to the expiry of the transitional license. Long-term care auxiliary hospital providing facility-based care becomes a Continuing Care Home Type A and are issued a Continuing Care Home Type A license. Designated Supportive Living Health Funded becomes a Continuing Care Home Type B and is issued a Continuing Care Home Type B license. Supportive Living Accommodations who are issued a license under the Supportive Living Accommodations Licensing Act that provide supportive living services in the accommodation are issued a Supportive Living Accommodation license. Operators whose licenses expire in March, April, and May of 2024 will be issued a license extension prior to their existing license expiring to provide for a seamless transition as possible to the Act. Transitional licenses are not applicable to Continuing Care Home Type C operators as they have never been licensed or certified. The following slides will go over what the steps of the application process are and the requirements. Here is an example of what transitional licenses will look like and what applicable operators will receive according to what services are provided. The first license shows only a supportive living accommodation license. The second license shows if a continuing care home has different types of facility-based care provided in different parts of the facility. Then one license will show the two continuing care home types in the same continuing care home license. For example, long-term care and designated supportive living provided. And the third, a continuing care home license for Type A only, long-term care. Topic 3. Initial licensing process. There are two reasons in applying for a license: initial licensing and renewal licensing. When there is a change in ownership, moving to a new location, or adding a new location, an application would be treated as initial licensing, requiring the supporting documentation of a new applicant. As licenses are not transferable, where there is a change in ownership or operator, a sale, the new operator must submit a new application within 60 days prior to plan changes. A renewal license would require a completed application form and indicating if there are any changes, including in supporting documentation as per the Continuing Care Regulation. To note, there are new reporting requirements in the Act and Continuing Care Regulation called Notice to Director, which is a notification that is required for a license holder to inform the director of substantial changes to the operation or ownership of the continuing care home or supportive living accommodation, apart from the time when the license renewal is due. A change in ownership falls under this reporting. Another requirement called Duty to Notify would be used to report on any changes to the content of the statutory declaration. Further information session, Part 3, will cover content on these reporting requirements. Initial application process. The ELF, Eligibility for Licensing form, has been eliminated. Information that was requested on the ELF is now collected on the application form. The ELF was a form to support in determining if eligible for licensing. Now this information is incorporated into the application form. If someone expresses interest in becoming a continuing care home or supportive living accommodation operator, they will now be sent the application form to complete instead of the ELF. No major changes other than some of the documentation that is required to be submitted. Once an application package is received, Alberta Health will review the application package to ensure that it is complete. If anything is missing, Alberta Health will contact the applicant and let them know what is required. Once all documentation is received, Alberta Health will review it to ensure that all documentation is correct. Alberta Health will work with the applicant to let them know of any deficiencies in the documents and what is needed to correct the deficiency. Once all documentation is accepted, a pre-inspection visit will be completed prior to opening to determine that the site is able to meet the requirements in the Act, regulations, and standards. This is not applicable to Type C continuing care homes. A recommendation for licensing will be made at this time. Licenses can be issued for up to 4 years. Should the director refuse to issue a license, the applicant will be notified in writing and be able to appeal the decision. The director may also impose conditions on the license. The applicant will be notified of the conditions and will be able to appeal the decision. For example, the operator is not able to move in any new residents without Alberta Health approval. The application form has selections you can check off for initial and renewal applications. The applicant would select what is applicable for reason in applying. Along with a completed application form and supporting documents are needed. What are the supporting documents needed? I will highlight what is new and what has not changed in the documents being requested, but further detail will be given when we go through the application form itself further in the presentation. Statutory declaration. This is new. This will set out all criminal charges, convictions, or civil lawsuits. The declaration must be signed by the operator. If the operator is a corporation, then must be signed by a registered officer of the corporation and a commissioner of oaths for the notary public. Insurance. This is not new. Commercial business general liability of no less than $2 million, and if money or personal property of the resident will be held, then contract insurance or an insurance policy in an amount covering the operator's potential liability resulting from theft, fraud, or other similar offenses, whether committed by employees or other persons. Compliance to the Public Health Act and Safety Codes Act. Inspections are needed to determine compliance from the respective agencies. This is not new. Fire inspection. This is not new, however there is an enhancement. If there are concerns with obtaining a fire inspection, the continuing care regulation states and enables flexibility to meet this requirement. If the applicant is unable to provide the results of a fire inspection, a safety inspection of the facility or part of the facility can be conducted by a safety codes officer designated as Fire Group B1 or Fire Group B2 in accordance with the scope of practice and entrance qualifications published by the Safety Codes Council if unable to provide results of a fire inspection, and the safety officer is satisfied with the results. This could be given to support this requirement is achieved. New buildings will have this covered under a safety inspection. Zoning approval, if required by municipality. This is not new. Corporate status, active and accurate status. This is not new. Third-party service agreement. This is new. Copy of applicant government issued ID. This is new. Further in the slides, we will speak about renewal licensing. To note that only changes to the supporting documentation would be submitted in renewals. As briefly noted on an earlier slide, an operator is a person or organization that operates either a continuing care home and/or a supportive living accommodation. Operators will be issued separate licenses for continuing care home and supportive living accommodation if the services are co-located. For example, if an operator offers long-term care services, Type A continuing care home, and supportive living accommodation services, non-health funded, 2 licenses will be required. Continuing care home operators with multiple types will be issued under 1 license. For example, if an operator of a continuing care home offers long-term care, Type A, and designated supportive living, Type B, only 1 license is required. An operator must submit 1 application per location. This means that facility-based care services and supportive living accommodation services provided are captured in 1 application form. For example, if your accommodation provides long-term care type A and designated supportive living type B, only one application is needed for the entire building. The application form would capture this information. Alberta Health will determine the licensing requirements. Select if you are applying for an initial or renewal license. Each field will describe the information that is required. There will also be a checklist for the supporting documentation in the application form, such as a statutory declaration. Completed applications can be submitted via mail, fax, and email. Alberta Health will deem an application timely filed and does not consider an operator as operating without a license while the application is under review. Should you have any questions about the licensing application process, please call or email the Continuing Care Licensing Office at 780-644-8428, cclo@gov.ab.ca. It is important to note that for any application, initial, amendment, renewal, etc., if the application has been inactive for 6 months, then a new application package must be submitted. On the screen, you will see the application form. The new application form contains information that was previously on the Eligibility for Licensing form, the ELF, which is discontinued as the Act is in force. We will go through each section of the application form and highlight what is new. Section A, Applicant Information, does not contain anything new. Information requested was previously gathered from the ELF or from the Supportive Living application form. Section B, Site Information, does not contain anything new. Information requested was previously gathered from the ELF or from the Supportive Living application form. Section B1, Occupancy and Building Description. This section is new, and this change was made to allow us to evaluate that the accommodation design is appropriate for the needs of the residents who will be residing in the accommodation. This allows us to be aware of any unique building characteristics, such as campus of care, multiple residential addresses, etc., that may need to be taken into account when issuing licenses. Section B2. Does the applicant receive any municipal, provincial, or federal funding? This section has been expanded to include municipal and federal funding. This information assists in determining license type and referrals to appropriate resources in the event of complaints. Federal funding you would see primarily with Indigenous communities and populations. Municipal funding is known in the province, and some examples include housing initiatives. Section C1. Will the applicant provide facility-based care? This section is new, as facility-based care was not previously licensed and did not have to apply for licensing. The information requested for single units, double units, current number of people receiving the type of care, and maximum number of people receiving the care is requested so we can determine that occupancy does not exceed permitted occupancy in building approval or occupancy permits, as well as to monitor changes to occupancy. Section C2. Will the applicant provide services as a supportive living accommodation? The information for single and double units is new. The rest of the information in this section was previously gathered on the ELF and Supportive Living Accommodation application form. The information on single and double units is so we can more easily determine that occupancy does not exceed what is permitted on building approval or occupancy approval permits. This information was previously gathered by inspectors during the initial inspection visit. Section C2A. Accommodation Services. Some of this information was previously gathered on the ELF. The information requested has expanded as the criteria for licensing has been expanded from safety and security and 1 meal per day or housekeeping to safety and security, meals and/or accommodation services. The list of accommodation services on the application matches what is identified in regulations. Section C3. Does the applicant contract with a third party for any of the management of the accommodation, provision of care, clinical services, provision of accommodation services. A copy of the service agreement is required. This section is new. This information is being requested so we have a clear understanding of the roles and responsibilities between operators and contracted service providers, and so we know who is involved in supporting residents. Some operators, for example, may contract for meal provisions or housekeeping services through another party. Section D, Correspondence. This is not new. The information was previously gathered on the Supportive Living Accommodation application form. Section E and F, nothing is new in these sections. Previously collected on the Supportive Living Accommodation application form. Contact information and how to submit the application information is provided, and you will see throughout the form buttons for resetting the form, submitting, saving, and printing. Next section is a checklist of documents to submit with your application. We will go over what stays the same and what is new. Articles of Incorporation. This is new, and this is being requested so we can verify information on the corporate registry documentation. Certificate of Status from Alberta Corporate Registry. This is not new, allows us to verify that the applicant is legally able to operate in the province. Incumbency Certificate or certified copy of the Limited Partnership Agreement if applicable. This is new, allows us to understand the roles and responsibilities of the partners. Statutory Declaration, setting out all charges, convictions, or civil lawsuits concerning the applicant, operator, to be witnessed by a Commissioner for Oaths Notary Public. This is new. Criminal record checks and vulnerable population sector checks are a practice in healthcare. The statutory declaration follows the same idea of risk mitigation for residents. General liability insurance, this is not new. Insurance policy for safekeeping residents' money and other personal property only if accommodation services includes trust accounts or safeguarding personal possessions. This is not new. Recent environmental health inspection, this is not new. Safety code approval for a new or renovated site, this is not new. Zoning approval, this is not new. Recent fire inspection report for pre-existing buildings, this is not new. However, what is new is the enhanced flexibility to meet this requirement. If the applicant is unable to provide the results of a fire inspection, then to be accepted is a safety inspection of the facility or part of the facility is conducted by a safety codes officer designated as Fire Group B1 or Fire Group B2 in accordance with the scope of practice and entrance qualifications published by the Safety Codes Council, and that the safety officer is satisfied with the results of the inspection. Third-party service agreements, this is not new and this was discussed earlier in the application form. Copy of applicant government issued ID, this is new and it's requested so we can verify the identity of the applicant. Depending on what was selected in Section A, which is for the type of business, then the appropriate statutory declaration form will be available to you.
Once Alberta Health has reviewed the application package and determined a license is required, an initial inspection of the premises will occur within a week of the scheduled date of opening. This is not applicable to continuing care home Type C operators. Hospices, continuing care home Type C operators will not be required to have a pre-licensing inspection upon implementation of the Act. They will be issued up to a 4-year license after application and supporting documents are received and criteria is met as determined by the Director, and will be visited by Alberta Health within 18 months of the Act's implementation. More to be announced on the approach, as currently accommodations and continuing care health service standards do not apply to hospice settings. Further communication will be shared with hospice operators on this process. Standards will be further reviewed post-implementation of the Act, considering what would be most applicable to hospice settings. More to come and will be communicated to stakeholders. A pre-licensing inspection may include touring the accommodation and grounds, reviewing all policies and procedures, and interviewing staff and residents and their legal representatives, if applicable, in the event of a change in ownership where there are existing residents living at the site. A license may be issued for up to 4 years. Topic 4. Renewal license. Renewal application process. 90 days prior to their license expiring, operators will receive a renewal notification, application form, and a list of documents that are required to be submitted. Please note that only changes in the information in the documents submitted from previous applications are required to be submitted. The application form and documents must be submitted 30 days prior to the license expiry date to provide for sufficient time for processing. No major changes other than some of the documentation that is required to be submitted. Once an application package is received, Alberta Health will review the application to ensure that it is complete. If anything is missing, Alberta Health will contact the applicant and let them know what is required. Alberta Health will work with the applicant to let them know of any deficiencies in the documents and what is needed to correct the deficiency. Once all documents have been received and approved, a license can be issued for up to 4 years. Should the director refuse to amend, impose conditions, or refuse to renew a license, the operator will be notified in writing and will be able to appeal the decision. For a license renewal, the operator would fill out the application form, check off the renewal box category, provide and submit only the information that has changed. If requesting an amendment, include the reasons for the amendments in the notes sections of the form. Supporting documentation may be required if applicable to the amendment request. To note, when renewing a license, environmental public health, fire inspections should not be older than 5 years. Zoning approval, if there is a change in use, if there are renovations or a change of use, safety codes approval is required. Topic 5. Licensing decisions. The director may issue a license for a term of up to 4 years with or without conditions, amend a license, impose conditions on a license, decide not to issue, amend, or renew a license. To note, the previous license duration was 3 years. That's now up to 4 years. The director may refuse to issue a license if any of the following are true: history of contraventions or failures to comply with the Act or other legislation such as Protection for Persons in Care, the Public Health Act, the Nursing Homes Act, the Supportive Living Accommodations Licensing Act, regulations under the Act and Supportive Living Accommodations Licensing Act, and the Criminal Code of Canada. Unwillingness or inability of the operator to operate in accordance with the Act, regulations, conditions, specified measures order or stop order, makes a false or misleading statement in the application or falsifies documents in support of the application, or fails to provide information under the application requirements. Posting of license, unless the director specifies otherwise, it must be posted in a prominent place in the facility. Topic 6. Appeals of licensing decisions. An operator has the right to appeal a decision made to refuse to issue, amend, or renew a license. The appeal is made to a minister-appointed appeal panel. The appellant must give notice of appeal to the Appeal Secretariat to start the process. The Appeal Secretariat, a neutral government office that runs separately from Alberta Health, will provide administrative support by scheduling hearings and provides information to all parties about the appeals process. Members of the appeal panel review all documents submitted by the parties, hear all evidence and arguments presented by the parties at the appeal hearing, and make the decision about the appeal. Appeals can be done by written submissions, in person, by electronic means, or a combination of these. As per the continuing care regulation, evidence may be given by the applicant to an appeal panel in any manner that the appeal panel considers appropriate. All parties can always submit additional information to the panel as part of their case, and the panel will review that when making a decision. The appellant would submit the appeal through the Appeal Secretariat.
The link is available on the Continuing Care website. What will be covered in the following sessions? In Part 2, it provides a general overview of the new Continuing Care Act, regulations, standards, and other key legislative tools. Discuss what's changing, what's staying the same, and what you need to know as an operator, provider, staff person, resident, client, or family member. Part 3, Compliance Monitoring and Enforcement, provides an overview of the compliance monitoring process, including changes and inspection guidelines for Type A, B, and C continuing care home operators, supportive living accommodation operators, and home and community care providers, and provides information on exemption eligibility and details regarding the enforcement process and penalty measures. Contact information is posted on this slide for the Continuing Care Licensing Office. For legislation-related questions, you may contact cclegislation@gov.ab.ca. That ends our session on licensing application. I appreciate your time and attention. Thank you.